Also, the seats up front are vacant. I request our audience to please move in front so that we can see your pretty faces. Lots of space. I hoped it would be. All right, a very, very good evening, everybody. We come to a close of day one in the plenary hall today with our session 4B. As is always imperative, we definitely tend to keep the most interesting sessions towards the end so that our audience and our delegates go back home thinking and pondering about issues. I'm very happy to be introducing the topic for today. It is International Commercial Arbitration, Lessons from the West to the East. The international commercial arbitration has evolved from being a purely academic concept to being the preeminent mode of resolving international disputes between commercial parties. This panel discusses a strong movement towards the worldwide harmonization of international commercial arbitration law and practice, which is largely driven by globalization. Lessons which India can learn from jurisdictions in the world that have made continuous efforts to introduce the best innovations in policing and enhancing global arbitration standards will be elaborated upon by the speakers. I welcome you all to this session 4B, and I'm very, very honored to be introducing the chair for today, Honorable Mr. Justice Shiavax Vazifdar, who is the former Chief Justice of the High Court of Punjab and Haryana. Justice Vazifdar completed his LLB from the Hinduja College, Bombay, and enrolled as an advocate in the Bar Council of Maharashtra and Goa in October of 1980. He practiced on both original and appellate sides in the Bombay High Court in civil, constitutional, company, and arbitration matters. He also appeared in the Supreme Court, various high courts, tribunals, district courts, etc. He was sworn in as the additional judge of the Bombay High Court in January of 2001. He was transferred as the acting Chief Justice of Punjab and Haryana High Court and was subsequently appointed as the Chief Justice of the High Court of Punjab and Haryana till his retirement in the year 2018. We welcome you, Justice Vazifdar, and we thank you for gracing the dais with your presence today. Thank you so much. We are also joined by an extremely distinguished panel of speakers today, and I would like to begin by introducing Professor Dr. Jacomijn Haersolte, who is the Director General, London Court of International Arbitration. Jackie has been the Director General of the LCIA since the 1st of July 2014. She regularly sits as arbitrator and has handled cases under the ICC, LCIA, UNCITRAL rules, as well as those of the Netherlands Arbitration Institute. She's also on the ICSID roster of arbitrators and was and is a member of several ICSID annulment committees, including as president. She's a professor of civil law, in particular arbitration law, at the Leiden University, and is a member of GA's editorial board. Previously, she practiced as counsel and arbitrator in The Hague, and at her GAR 100 boutique, Haersolte-van, which she set up in 2008, after 3 years as counsel in the International Arbitration Group at Freshfields Broekhuis Deringer in Amsterdam. Ms. Jackie regularly sits as arbitrator and has a million responsibilities that she undertakes as the Director General at the LCIA. We welcome you, Jackie, and thank you so much for gracing the dais today. I now move to our next speaker, Mr. William Rowley, KC. Mr. William is a highly experienced international arbitrator and joined 20 Essex in 2002. His practice at the bar covered all aspects of international commercial law, including competition, contracts, banking, oil industry, insurance, corporate governance, and arbitration law in practice. Mr. Rowley was elected as the chairman of the Canadian firm Macmillan LLP in 1996 and the chairman emeritus and special counsel on his retirement from partnership in 2009. He relinquished these roles in 2014, but while at Macmillan, Bill headed the firm's competition law group from its inception and oversaw the development of its arbitration practice. Mr. Rowley has chaired or participated as a tribunal member in over 200 international arbitrations that have involved a variety of national laws and investment treaty systems. He was a member of the LCIA court for 2 terms, serving as the chairman of the board of directors until the year 2017. Thank you so much, Mr. Rowley, for joining us. We are very pleased to have you. Last but certainly in no sense the least, I would like to introduce Mr. Manish Aggarwal. Mr. Aggarwal studied law and humanities at our very own Nalsa University of Law in India and holds a postgraduate diploma in international arbitration from Queen Mary University of London. Mr. Aggarwal is a dual qualified English solicitor and Indian advocate and a partner in the 3 Crown London's office. He has extensive experience of representing clients in both commercial and investment treaty arbitration across a broad range of sectors, including energy, infrastructure, life sciences, telecommunications, and technology, and in arbitration-related court litigation. Mr. Aggarwal is co-chair of the LCIA's Young International Arbitration Group and serves as a faculty member of the DELOS Dispute Resolution's Remote Oral Advocacy Program, which I must say individually I myself have taken. He regularly teaches commercial and investment arbitration law at a plethora of law schools. Thank you so much, Mr. Aggarwal, for joining us today, and we are very pleased to have you on board. I would now like to hand over the reins of this session to Justice Vazifdar to take it forward, please. Thank you so much.
Thank you very much. Good evening. You must be tired. There was one sentence in the Chief Justice of India's address yesterday at the inaugural function that sums up the value of this event. He said, "This event strengthens India's arbitration ecosystem." The only thing that surpasses the intellectually stimulating topics and the outstanding arrangements made by the DIAC is the warmth and hospitality of the judiciary in Delhi in every respect. From the Chief Justice to his companion judges, to the staff, and to all the interns who seem to be working tirelessly. And as one of them just told me, but this is only the first day. It is an honor to be invited to this conference, and it is an honor to chair this session with some of the most eminent and highly acclaimed persons in the field of international commercial arbitration. Before going further, I must mention, as I always do, that I do not express any view as a matter of policy on questions of law. And today, in respect of the first point, I would emphasize that. There are innumerable lessons to be learned from time to time. My co-panelists will be discussing them under 3 heads. But before that, I would like to flag 2 issues. And let me make it even more interesting for you. None of the panelists over here think it's of much relevance. So that's going to be a robust session. I don't intend dealing with the issues of practice, the best practices, etc., because my co-panelists are really the experts on this. But there are 2 issues which have been troubling me for a little while, and that is why I want to flag them. I think both are serious. I intend emphasizing the need for 2 things. On the one hand, reciprocity, uniformity, comity, certainty, comity would normally follow the first three. And the second category is with respect to finality of the reference. Now, one of the best illustrations in respect of the first category, which worries me, is the heated, rather very heated debate on the question as to whether an annulled award at the seat, at the court, by the courts at a seat, can be enforced in another jurisdiction. The debate centers around Article 5(1)(e) of the New York Convention, which provides that the recognition and enforcement of the award may, the word may is emphasized, that's where the controversy is, may be refused if the party furnishes proof that the award has been set aside or suspended by a competent court of the country in which, or under the law of which, that award was made. Now, several countries have taken the view that even though an award has been annulled by the courts at the seat, it can still be enforced in the country where it is sought to be executed or even relied upon. Let me make it clear at the outset that I do not intend advocating the pros and cons of either view. As I mentioned at the outset, I do not express an opinion on questions of law. But I have no hesitation in emphasizing anything that strengthens the system. Uniformity, certainty definitely does strengthen the system. Now, I will use Professor Francesco Cassio's categorization of the view that you can enforce an annulled award. After surveying the decisions of various courts, he categorizes them into three categories. Those enforcing the award in accordance with domestic law. So, for instance, in France, notably in the three well-known cases, the Court of Appeal, the highest court of appeal in France, I think the Cour de Cassation, I'm not too sure about the pronunciation, pardon me, has held that so long that even an annulled award can be enforced, so long as it is in conformity with French law. That is the simple principle. This view has commended itself to various scholars, arbitrators, and academicians. The second category are those courts that ignore the annulment decision. Now, they ignore the annulment decision on various grounds. For instance, and Professor would be in a better position to tell us if she wants to about it, but for instance, in the UCOS case in the Netherlands, the award was enforced despite the fact that it was annulled on the ground that the country in which the annulment proceedings took place did not have a reliable system, either the judiciary or the executive or the litigant, and there was far too much interference, and the award would not, and the order could not be impartial. The third category are those judgments which assess the annulment decision in order to determine if it deserves deference. So one court in one jurisdiction, therefore, feels free to decide as to whether another court at the seat decided the case properly or not. As I said, there's considerable support for this view. Now put yourself in the position of a person who has obtained an award and it is set aside by a court at the seat on some technicality or on a ground that the enforcing court does not agree with. There is something to be said that ultimately justice is done because the person who has obtained the award has seen the fruits of the effort, time and effort and money spent. That's one view. there is an equally strong and well-reasoned view to the contrary. And for those of you who, few of you who may not be aware of the controversy, let me tell you that the opposing view is not just strong, it is scathing. Some of the comments, I think I would refrain from even referring to at this conference because we are not here on the merits of either view. Peter Sanders, who had a key role in the drafting of the New York Convention, says that it was clear when the convention was drafted that an award annulled by one court of the seat, annulled by the court of the seat could not be enforced in another country, as once vacated, it no longer exists and its enforcement would be against public policy. This view has been supported by other scholars as well. M.D. Holmes in an article argues that there is a fundamental difference between the court hearing the annulment proceedings and the court hearing the enforcement proceedings. I do not even suggest which view ought to be accepted. My endeavor is to emphasize the necessity of accepting as expeditiously as possible one view or the other, or leaving the matter open. This is a controversy crying out for a resolution and an expeditious resolution. For lawyers and arbitrators, the debate is intellectually stimulating and rewarding in more ways than one. For the poor litigant, it is draining, again, in more ways than one. What the commercial world wants more than anything else is certainty. Certainty of the law is often more important than the acceptance of the legal principle or the legal provision itself. As someone told me in respect of another panel that I am involved in for taking a new look at something, the takeover code, mentioned that if there is a legal principle or provision which I don't agree with, I don't mind so long as it is certain, because then I can work my way, I can work my transactions around it. But if there is a legal provision which I think is good, it's of no use to me because it keeps everything uncertain. The reason why I am anxious about this whole thing being resolved is that it appears as if this controversy today is contained. But I am apprehensive that it is not going to remain contained for a very long time. There are three repercussions. Firstly, it is going to spread geographically. There are 171 signatories to the New York Convention. If each one of them starts taking a different view, it's going to be difficult. Secondly, it's going to spread to other forums, because if a point of law can be taken about the enforceability of an annulled award in courts, it can also be taken before other forums, especially before arbitral tribunals and quasi-judicial authorities. And lastly, there is no stopping the widening in terms of content. If you can ignore a judgment annulling an award, you can equally ignore a judgment that accepts the validity of the award and its enforceability. So you have pros and cons on either side. The point I'm trying to make is that it is imperative, therefore, for any working committee of the New York Convention to monitor a situation in international commercial arbitration on an ongoing basis and not merely just once in 5 years or 10 years. Take a decision one way or the other, either this or that, or neither, but let the commercial world know what it has. Take another simpler example. There is a debate, of course now no longer in India, about emergency arbitrators. What if one country recognizes emergency arbitrators and that award cannot be enforced in another country which thinks it's against public policy? All right. The need, therefore, for certainty is there. A solution is required. But the solution looms way beyond the reach either of the judiciary, of the legal fraternity, of the litigant. The solution lies only with the legislatures of each country. Because this requires legislation. And legislatures can come to a conclusion only on a common platform, a convention such as the New York Convention. There is no other solution, no other place to look for a solution. A lot was said yesterday about India adopting international best practices. I am not going to go into that because that is a very interesting topic which my panelists who are far more experienced on this will be addressing you on. Now, I know most of you must be familiar with Vanessa Williams' song, Save the Best for Last. I have saved the worst for last. I think my panelists will tell you that the only polite comment I've got so far from all my friends, including my friend Abhinav Bhushan, I don't know if he's here, is...
Right here, sir.
Oh, you're right there. Okay. He's not embarrassed to say that this is the worst for last. Okay. But before you attack me, forget that you are lawyers. Forget that you belong to the legal profession. Put yourself in the position of a litigant who has obtained an award and the award is set aside. The only solution, and this is one point on which we are all in agreement, the only solution that you have today is either to go for a fresh round of arbitration or to file a suit. Now, this is exactly what litigants have asked me. What do we do? Where is the certainty about the fresh round of litigation and the arbitral award? Now, in view of the opposition that I have, one thing is for certain. A solution is needed. But in view of the attack, I'm far too scared right now to provide the only solution that I can think of. I would only request you not to reject the thought straight away, but I think international commercial arbitration, if it leads the way, can find a solution, because otherwise, I know it happens very rarely, but put yourself in the position of that litigant who has got an award and it has been annulled. Are you going to put him through the entire grind again, or are you going to find a way of making not the award final, mind you, bringing the reference to a finality? In a court of law, there's no problem. You go to the appeal court. The appeal court can hold in your favor on different points. It can overturn the whole judgment. Arbitrators don't have that. With that, let me start with the less controversial part, and that is the various topics that my panelists are going to enlighten all of us on. I look forward to that. Let me start with Jacomijn Haersolte. Am I okay on that? There's one thing we were both agreed on. Both of us have difficult names. Oh, and there's another thing. At the end of the little powwow that we had, she said, there's one other aspect of uniformity among you. The three of you are wearing ties of a similar color. But there ends the agreement, so this is going to be a robust session. All right? All right. Professor, can we now request you to discuss the need for a robust and an up-to-date national arbitration legislation? I know you have been involved in this as far as the English Arbitration Act is concerned, and with the reforms of the Dutch Arbitration Act. Over to you.
Thank you. Is it working? Yes,
Yeah,
I think
I
it's
put
working
mine.
now. Thank you very much for these thought-provoking initial comments, and you stole my thunder with the reference to your ties, but there you go. You rightly stressed the importance of uniformity, and I suggest to you that there are two considerations that deserve probably equal consideration in this entire process: uniformity and quality. And that ties into the theme of our panel, East and West, what can we learn from each other? If you look at how the law, where the law comes from, there are several sources, and one of the obvious sources is national legislation, in addition to case law and scholarship. So we decided to start this discussion with some thoughts from our side and hopefully questions later on national legislation. But before delving into the substance, I would just like to remind us all of some of the profound words issued yesterday by the Chief Justice in his introductory comments when he referred to the need to share failings even, that this is not an acknowledgement of the grass being greener on the other side, but it is the best way to improve the process, and as I see it, in particular, the quality of the process. So I bring to you some experience when it comes to national legislation, having been involved a while ago in changes, actually on two occasions, changes to the Dutch Arbitration Act, and more recently in my LCIA capacity, I have become involved in changes to the English Arbitration Act. And the reason why I think that is a helpful starting point is it illustrates better than anything else that even jurisdictions like the Netherlands, which has an important shipping practice, and the United Kingdom, with London being a premier seat of arbitration, still having the need to revisit the law and legislation from time to time. In order to stay best in class, you need to keep an eye on things. You need to make sure that your legislation is best in class. And that includes looking at other jurisdictions. And we'll hear more shortly also from the Indian perspective, but this is an ongoing process. So what I'd like to do is make a few observations about the legislative process generally, and then identify a couple of topics and what the thinking is on these topics and how potentially that can lead to discussion elsewhere, including in India. Maybe a few comments about the role of the LCA in the legislative process. Many of the LCA's cases are seated in the United Kingdom. That's not our choice. That's not necessary in any way. It is a fact that also because many cases involve English law, despite the fact that most users are not English, they still choose London as a seat. And that makes it extremely important to ensure that the law is not only good, is not only uniformly applied, but that it is clear what the law is. So very obscure provisions that require only English lawyers to interpret these provisions is not helpful. To some extent, an arbitration law is the calling card of a country, and it needs to be understandable also to its overseas users. So as an institution, we felt it was extremely important to engage in the legislative process, which I must say, coming from the Netherlands, I thought was remarkably organized. In the Netherlands, it was a private initiative that led, after about 10 years, to actual legislation, where we were entirely dependent on the Ministry of Justice to take up the private proposals. In the United Kingdom, there has definitely been some, I would say, lobbying to review the Act, but it is very much a centrally coordinated effort to first come up with a consultation paper issued by the Law Commission and a very organized process of taking soundings from the users, which has included the LCA. And what has been very interesting about that process, picking up the point of uniformity, is that users are not uniform. So when I speak from my LCA position with international users in international cases, that can reflect a very different perspective from, for instance, maritime arbitration practitioners who arbitrate in ad hoc proceedings and may have very different ideas about some of the issues that I will shortly highlight. So what are some of these issues? One of the issues that I'd like to mention is confidentiality. This is a topic that is discussed all over the world and where there is no uniformity. There are many legal systems now where the case law codifies to some extent the right to confidentiality, but in particular the scope of such right is very much a question. So England also has fairly detailed and elaborate case law confirming that there is confidentiality in arbitration, but that is not foolproof. And the LCAA, therefore, has an explicit provision on confidentiality, Article 30 of the LCAA rules. So one of the things that we as an institution wanted to ensure with this whole legislative provision is that the features that we deem important to our users are not jeopardized by the legislative process. Sometimes perfect can be the enemy of the good. And confidentiality is an example where my Dutch experience helped my English role, because confidentiality was a red flag when the Dutch provisions came to Parliament. When we started our private discussions about confidentiality, there was consensus amongst our little group that we should aim for an opt-out provision of confidentiality. 10 years later, when the matter was going to Parliament, the mood had changed, largely as a result of the discussion in relation to investment arbitration, and even parliamentarians who couldn't even spell the word arbitration had a sort of bad feeling about it, and the last thing that we would be able to achieve was an opt-out. So the result was an opt-in provision in the Dutch Arbitration Act. So for me, that was a sort of warning signal. Now, the Law Commission has, for now, proposed not changing anything and not including a statutory provision on confidentiality, which I think is a good thing. And it's a paradox, because I do think that confidentiality is one of the hallmarks of arbitration. But not only the political sensitivity, also the difficulty of coming up with a really good statutory provision makes it a fairly unattractive provision to address. The second one is independence and impartiality, and the related disclosure obligation. That, to us as an international institution, is vital. But picking up my point about different perspectives from different users, how we perceive independence and impartiality to function is not something that all users are agreed on. There is a provision in the English Arbitration Act, but it only refers to impartiality. So one of the questions is, should there be a reference to independence as well? Ideally, I think there should be. The LCA rules have an explicit reference to both. Personally, I don't think that this is going to work because there is too much resistance, and it is a complicated discussion. I personally think to some extent semantic, but what we as an institution did feel strongly about is that a codification of the disclosure obligation is extremely important. Arguably, because this is something you put in your rules, it is not necessary, but for international users, the existence of an explicit disclosure provision is, I think, an important safeguard that people would like to see in the Act. I'd like to mention, as a third point, the discussion about the scope of review of jurisdiction of a tribunal. And this is an interesting one if you think about the power of case law as a tool for uniformity. So currently the law in the United Kingdom, or at least in England and Wales, is that there is de novo review of jurisdiction when it comes to arbitration agreements. And I think that's a good thing. That is the law in the Netherlands as well. But that is not a given. A couple of years ago, that was not so clear. There is now a suggestion that the review might be more modest, and that is in part a reflection, or said to be a reflection, of the right of arbitrators and party autonomy to be the final arbiters of jurisdiction. I think as a matter of principle, that is simply flawed. But in addition to that, I think that actually what we have seen in relation to the discussion of de novo review is that there has been a lot of harmonization through case law. If you look at the key English cases on this issue, they are referred to in other jurisdictions, whether it is Canada or even the Netherlands. So we're seeing uniformity being brought about by cases. And where you have a winning team, I suggest you should not tinker with it. Court orders in support of arbitration is another matter being discussed, and we may touch upon that later in this discussion today. Summary disposition, same. And I'd like to conclude by one topic which again illustrates that there is not necessarily a one solution option. Section 69 deals with the appeal on a point of law, which is currently something you can opt out of, and that's what most international institutions have done in their institutional rules. Many feel, and I certainly as an individual feel, that that is not enough. I'd prefer this, if anything, to be an opt-in. But here we see some of the users who feel that this is an extremely important safeguard for their type of arbitration to wish, if anything, more. And therefore, I think in the end, the Law Commission is going to come out saying, let's not tinker with this. This is probably the ultimate, the optimal solution. So I'm going to end with this one because it's a very good illustration of what you need to do when you review legislation. Even if you decide not to do anything, it is good from time to time to review the statute. It is not good for users if legislation changes every 2 or 5 years. I don't think it's good for users if institutional rules change every 2 or 5 years. That's, to me, a suggestion that there's something wrong with the rules in the first place. But to provide some stability, and maybe I can throw that into the mix of comity, uniformity, harmonization, and quality, is extremely important. But that does not mean that we should be complacent, and it means that we should also look at what our neighbors are doing. So on that, I'd like to give the floor to my colleagues, and perhaps first Manish to talk about the Indian situation.
Thanks, Jackie, and good afternoon, everyone. I will discuss India's approach to amending its national arbitration legislation, the Indian Arbitration and Conciliation Act 1996, and how that has affected the international arbitration community's perception of India as an arbitral seat. And I'll share some views from my own perspective as an arbitration practitioner educated in India, but somebody who's practiced physically from outside of India for the last 15 years, and as somebody who's often been asked to advise by clients on the choice of India as an arbitral seat. And let me start by acknowledging the monumental changes that have taken place in the Indian arbitration landscape over the last few years. Over the last few years, we have seen an extraordinary number of measures by all three wings of the Indian state, the legislature, executive, and judiciary, to develop India as an arbitration-friendly jurisdiction. And this has encompassed three significant amendments to the Indian Arbitration Act in 2015, 2019, and 2021, as all of you are aware. However, despite these efforts, I think the global perception remains that these measures are well-intended, but India needs to do a lot more spade work before it can really emerge as an arbitration hub, as a seat that not only domestic Indian parties will adopt, but as a jurisdiction that even foreign parties would feel comfortable choosing as an arbitral seat. In highlighting these issues, what I don't propose to do is to just add to a chorus of voices highlighting the shortcomings of the Indian arbitration landscape. That is not my intention. It is also not my intention to suggest that India should not chart its own path, should not develop its own indigenous solutions to the unique problems that our country faces. But I think for all of us who care about the Indian arbitration process and who wish for it to be the leading arbitral hub, I think it's important for us to recognize these issues so we can take steps to address them. Because going to the theme that Justice Vazifdar and Jackie mentioned, when it comes to the choice of a jurisdiction as an arbitral seat, certainty, predictability, and efficiency are absolutely key. Year after year, surveys of users of arbitration tell us that the user perception is absolutely key to the emergence of any jurisdiction as an arbitral hub. And in fact, when asked in Queen Mary surveys, several users have recognized that in addition to the general reputation and recognition of the seat, users often look at the national arbitration legislation as part of the legal infrastructure that exists in any jurisdiction, and the track record of any jurisdiction in enforcing arbitration agreements and arbitral awards. So how is India perceived globally today against these criteria that users focus on? And to this end, in fact, I asked an in-house counsel whom we work with and who has done considerable work in India to share his views on the subject. And she said that there's one word that can neatly encapsulate the current state of Indian arbitration law. And the word she used was uncanny. It's a good word. I think its dictionary meaning is strange or mysterious, impossible or difficult to explain. For example, as things stand today, if you asked a simple question about the precise legal regime that applies to your arbitral proceedings or your arbitration-related court litigation in India, the answer will entail a mind-boggling analysis with a very complex flowchart. You'll have to go through a whole analysis as to when the arbitral proceedings were commenced, when the relevant amendments to the Act were made, whether those amendments were prospective or retroactive, and then you look at a whole series of cases of the courts only to figure out an answer to the simple question, which law governs my arbitral proceeding or an arbitration-related court litigation. Let's ask another question that is often asked by users outside of India. Can a foreign lawyer participate in an arbitration seated in India? I've asked this question of my friends, and I'm sure you'll have better informed views than me in particular. But again, the answer is wholly unclear as things stand. Because in Balaji and the Bar Council of India, the Supreme Court said foreign lawyers are not completely debarred from participating in international commercial arbitrations seated in India. The position, at least to me, is wholly unclear as to whether you can have a foreign lawyer in a purely domestic arbitration seated in India between two Indian parties. even for international commercial arbitrations seated in India with one foreign party, the Supreme Court held that foreign lawyers who participate in such arbitrations would be subjected to the code of conduct applicable to the legal profession in India. And I believe the Bar Council of India was urged to come up with guidelines in that respect. Again, I don't think there is any further guidance on that. Finally, a question is often asked, well, if I seat my arbitration in India, could I have a venue of my arbitration outside of India? Would that distinction between seat and venue be recognized? And the answer to that is yes. Indian law recognizes the distinction between seat and venue. It's embodied in the law. But let me write you a memo with 10 conflicting judgments, just so that you have a complete picture of what that position is. And again, that lack of clarity detracts from users' choice of a particular jurisdiction as an arbitral seat. I think in terms of the court's approach to enforcement, I think it's fair to say that the courts are broadly taking a pro-arbitration approach to enforcement. We often hear the mantra, minimum intervention and maximum execution. But I think the legislation itself, going to the point that Jackie made, keeps evolving in rather strange ways. And it's often a case of one step forward and then kind of taking 2 steps back. All of you are well familiar with the amendments around Section 36 of the Arbitration Act, where in 2015 the law was amended such that a mere challenge to an arbitral award did not result in an automatic stay of the award. But again, I think in 2021, the proviso that has been introduced, I understand without much consultation, now suggests that if the court is prima facie satisfied that the making of the award or the underlying agreement was vitiated by fraud or corruption, then essentially you get an unconditional stay of the process. Again, we've seen that change in a very quick period, and again, that detracts from fundamentals. I think so. To summarize, I think the heart is in the right place. I think the intention is right. I think every organ of the Indian state is working towards correcting these deficiencies, but I think we need to recognize that there's a lot more we need to do before India can be seen as a choice of arbitration, not only for India-seated matters, of course, for between domestic arbitrations between 2 Indian parties, but globally as an arbitral hub. I'll pause here and invite any further reactions from Jacomijn.
May we request you to supplement on both the questions?
Yes, and my microphone is working. I used to be involved with the International Bar Association, and inevitably, when we had panels, it was very difficult to stay on time. And I think we're probably over time on this section, so I'll be very, very brief. India, and I've been watching India for a very long time, and especially the arbitration space over the last 15 years, and it's come wonderfully far ahead. And the degree with which arbitration is central to the business community in the effective resolution of its disputes is huge. But it's not. Oh, wait, am I not working at all? I won't repeat what I've said, other than to say you've been doing fantastically well. Are you going to be chosen as a seat by your international counterparties? For the moment, no. The reason that people look at seats, or should be looking at how to choose a seat, one of the first things is the national law on arbitration, because it governs the arbitration agreement between the parties, and its mandatory provisions will be there unless the parties, through their arbitration agreement, specify another law to apply to the arbitration process, and they very seldom do. Perhaps the most important point next that they look at, or perhaps it's the most important, is, are the courts arbitration friendly? And by that they mean, do the courts interfere inappropriately with arbitrations? And the thinking has been, rightly or wrongly in the past, that Indian courts were inclined to interfere too much. You all heard the Chief Justice last night. He set a very high goal, and it was wonderful to hear the plans in that regard. And we're all very hopeful that India will become a very important hub for arbitration. But you don't have to be a seat all the time to become an important hub. I look at this center, I mean, if, and forgive me, here's a word of criticism, I understand the center is only available if you apply DIAC rules. Well, get rid of that rule immediately, say that you're open to business if we have the space to anybody, and people will flock here. It's a wonderful place. And I'll be quiet now. I've got more to say on other subjects.
Then,
Should we open it for questions?
No, we'll be doing it at the end.
Oh, sure.
Yes. So we thought we'll finish the 3 points and then keep it open.
Yes, sure.
We'll, Mr. Rowley, you can't get away that soon. I'm going to request you to start with the next topic, and that is the cultural considerations in arbitration advocacy. East meets West. If you can discuss with us your experience regarding international arbitration from the arbitrator's perspective, and what arbitration counsel need to bear in mind with the tribunal members from different legal and cultural backgrounds. I would be particularly interested myself in this.
Well, I'm going to start. Am I here with you? Yes, I am. I'm going to start with a time traveler experience, and I'm going to take you back 50 years. 50 years ago, arbitration could hardly be spelt by anybody, and certainly arbitrators were only chosen from professors in France and Switzerland. You had to be at least 60, and you weren't paid anything to do it. It was an honorary thing, and there weren't many arbitrations. Today, the world has changed. In every country in the world that I know, there is an arbitration community. Most law firms have specialized arbitration units, and corporates worldwide, and it doesn't matter where we are on the spectrum right now of globalization, corporates who have deals with counterparties in other jurisdictions where they don't know their courts will always mistrust the courts of the other, and that means arbitration, and it's here to stay. Now, is it doing a good job? I'll say perhaps a bit more about this when we come to the next topic of efficiency, but the answer is it's not doing the job it should be doing. It's become too costly, it takes too long, and we'll say about that, more about that when we come to efficiency. But I suppose the tagline I would put on this session from my perspective is, if I were advising arbitration counsel on how best to proceed before their decision maker, remember this old adage: it does not pay to irritate the mind of he or she who is going to make the decision. So I'm going to tell you what irritates my mind and a lot of minds of arbitrators I know in terms of your presentation to them. Not necessarily in order of priority, but pleadings. Pleadings used to be, now we use a memorial process, as we all know, most of the time in international arbitration, as opposed to standard pleadings we see in courts. And they're wonderful, but they're much, much, much too long, and unnecessarily so, mostly because they're intensely repetitive. And if you're an arbitrator and you read a memorial which says everything 3 times, you say to yourself, they don't trust me to read it the first time and understand it. And they want me to spend hours and hours and hours reading it and seeing if there's anything new. Usually it is all said in the summary in the first 10 pages. All I can plead is be briefer. As somebody once said, plead with a cramped pen. Do not repeat yourself, and in your first draft, put in every adjective you can. But when you read it again in the morning, take all those adjectives out. They don't help your pleadings. And go directly to the point, the kernel of the case. Avoid all the chaff, and do not put in losing points or highly contestable points that you think you're going to lose, even if your client says, we expect you to argue that. It's going to diminish the client's case, and it's going to diminish your reputation if you spend too much time on nonsense. So, pleadings, that's one thing. Hearings. But the next thing, I think, is probably the procedural order number 1. Pay attention right at the beginning of the case, come to grips with the tribunal, try and get something that manages the whole process that everybody understands, and so there are no surprises as you go along. Quick next point. The International Bar Association about 20 years ago put in IBA guidelines on disclosure of documents. They were intended to bridge the gap between common law systems and civil law systems where there was too much disclosure and none. They were very good guidelines. They are now universally disapplied by people seeking enormous production. We have hundreds of pages of red ferns. Good tribunals will say in their procedural order number 1, we are going to be guided by these. We're going to set certain things in front of you, and if you do not apply them, we're not going to rewrite your questions to make them compliant. Hearings. Well, before the hearing, even if I've not convinced you to get rid of overlong pleadings, please do a skeleton 10 days before your hearing. That will get you to focus on the most important bits of your case and get it before us. If we have a skeleton and we've read your pleadings, and I promise you, everybody on the tribunals that I sit with read your pleadings because we discuss your case beforehand. So we know your case. So don't think that old-fashioned, long-winded openings would be a good idea. They're not. Use your, because we're going to make your hearing time much shorter than you're used to in courts, concentrate on the evidence. Concentrate on your cross-examination because you're going to take the examination in chief as being the written statements, and cross-examine on important points. And don't feel that it's good cross-examination to take a witness through a lot of documents because we will have read them. And one way to make sure that you don't have to do that, and I think I'm going to probably stop here, but I'll say something about closings, is consider putting in your pleadings a chronological list, perhaps in an index, of your most important documents and have them hyperlinked. Now, you see, I read your pleadings and I think they're interesting and that helps guide me. But 99% of cases are going to be decided on the facts. Where am I going to get the facts? The witness statements or the contemporary and the contemporaneous documents? If I have that chronological list of your most important documents and they're hyperlinked, I can spend less time on your pleadings and look at the facts, and they will support your case or not. Final point, I think, counsel these days want to spend time opening, having a showcase opening, when I've told you it's not necessary because we've read your skeleton, we've read your pleadings. They don't want to have oral closings because they're too hard work after hard week, and they have to stay up all night getting ready for them. But do that. because we will, as a tribunal, never be closer to your case than the last day of it. And if you can sum up and tell us what we have learnt from the hearing and why that makes your case compelling, that's going to assist us enormously, and it's going to assist you enormously. Enough from me. Who's next?
Manish is going to share his views from the Arbitration Council's perspective.
Thanks, this is Vazifdar. And I don't think I can improve upon what Bill has said in terms of what you need to do as Arbitration Council to be an effective advocate. I think what I was going to do in terms of the theme of the session was to just highlight from an Arbitration Council's perspective the cross-cultural considerations that you need to bear in mind to be able to adapt your strategy to achieve the best outcome for your clients. I think we are moving towards a world of arbitration that is increasingly being homogenized, with the rise of institutional arbitration, soft law instruments such as IBA guidelines and rules, and of course cross-border sharing of best practices. But we all know that important differences still remain, and you have to be able to appreciate those differences and adapt your approach. And I think the significance of this is only going to increase for us as we push for greater diversity across all aspects of our practice. I think we need to be culturally aware arbitration advocates to be effective going forward. And let me just expand the scope of the discussion beyond advocacy, just in terms of how an awareness of these differences across jurisdictions, across legal backgrounds, across cultures permeates each aspect of what we do. Let's take the case of selection of arbitrators. And this is based on the discussions we've had during this trip to India, and I was quite struck by the difference, because I think we've all gotten used, in major arbitrations in the West to interview potential arbitrator candidates, not to of course evaluate their views on substantive questions, but to ascertain their availability, their general experience. But in the discussions we've had over the last few days in India, I learned that actually in the Indian context, it would be highly inappropriate, depending upon your arbitrator, to actually suggest interviewing your arbitrator. And again, it may vary, across arbitrators. But again, that is something you need to be aware of. For example, if you are your international practitioner focusing on disputes with an Indian nexus. Again, let's talk about the procedural conduct of arbitration. As Bill mentioned, the predominant practice now in international arbitration is to have memorial-style written submissions. Submissions that are accompanied not only by documentary evidence, but also by the witness and expert evidence on which a party relies. But again, when you're faced, and again I'll take the example of India, I understand that in a domestic arbitration in India, or in terms of how Indian practitioners and Indian arbitrators may approach the matter, it may not necessarily be the starting point that the pleadings will be done in a memorial style format. In fact, I understand that quite often you may not even have detailed submissions on the law in your initial pleadings, and those legal submissions are developed for the first time at the hearing. And again, it's quite important to recognize that, so that you can anticipate what may be said by your counterparties, or how your arbitrators may be inclined to view the procedural conduct of the matter, so you can again tailor your approach on that basis. And finally, I'll conclude with one thought on oral advocacy, and it goes to cross-examination of witnesses. I think in most cases, typically, you ask yourself a threshold question as to whether or not you're going to cross-examine a witness at all. So you look at your case theory, you look at the propositions you wish to establish, and then you look at the witness's evidence, and you try and establish whether this witness actually is going to address those propositions, and is he or she going to help you achieve a certain result in terms of those propositions. And if you have a witness who does not address those matters, in some cases, and I think you will actually say to your clients, you're not going to cross-examine that witness, with comfort in the fact that that will not be taken as an admission. And again, most procedural orders may actually provide for that, particularly in the context of international arbitrations. But again, I'm told by several friends in India that that presumption may not necessarily be correct in the Indian context as well. Again, you have to see who's on your tribunal. But what you don't want to do is to not call a witness for cross-examination only for you to then be found to have admitted that witness's testimony. Again, I think, and I'll conclude with that, and I think again there's a greater homogenization of that. American-style jury-based aggressive advocacy usually would be frowned upon, if you look at the East. And I can share my own experience when I started cross-examining, almost 10 years ago. I started with the cross-examination of a very senior, government official from India. And I realized that every single time I pushed the point, I was aggressive, arbitral tribunal that included several eminent members of the Indian bar actually became more protective of the witness. And actually it was counterproductive to be aggressive. And therefore, again, you have to really, again, tailor your approach based on whom you have. But I'll stop here.
We'll now move on to the third.
No.
Oh, sorry. I'm so sorry, Jackie. Because you come in third and you come in again. So I'm sorry.
That's exactly right.
Yeah, so, Jackie, you'll supplement both these
Very
issues.
briefly, a few supplemental points on this very important issue. Arbitration advocacy, of course, relates to the law and the practice. So there are some things which are simply informed by the applicable law. Whether, for instance, you need to provide legal authorities up front, or whether you are allowed, as a matter of law, to supplement by bringing new authorities to the attention of the tribunal in the hearing simply because there is freedom to do so, because the tribunal is supposed to know the law and there are no restrictions in this context. That's an example that you see when civil lawyers enter common law-based arbitrations. So even within East or within West, there are differences. And it is this awareness that I'd like to pick up and provide some few additional comments on. I think somebody's cultural setting is a very wide concept and is not only cultural in the sense of the jurisdiction that you come from, but it goes to your gender, it goes to your seniority, it goes to so many issues. And again, awareness is key. Awareness of all the stakeholders in the process. I've seen, in particular, female arbitrators being much more explicit and transparent, and in my view, organized about how they want the proceedings, the way they want their documents structured. And I think it is very helpful to have those discussions and to learn from the guidance that you will get from your tribunal in that respect. I think an issue which is never discussed enough is seniority and what works in a hearing in terms of delegation of tasks. Only too often you see the most senior member of the team deal with the high-level, introductory, not necessarily difficult issues. They can be the most important general issues, but actually in terms of keeping a control over the case, it may be that the quantum issues in the case are the most thorny, and they tended to be delegated to the most junior partner simply because nobody else has any appetite to deal with it. And I think especially where there is sensitivity about hierarchy, about seniority, it can be very difficult to confront these issues. But I think that's part of what we need to do when it comes to addressing best practice. And it is awareness about which individual you have in front of you. And if you get guidance from an arbitrator that the only time left is 10 minutes, then stick to the 10 minutes. Drop indeed, as Bill said, the points. I think the most effective advocates I have seen, wherever they come from, is fight the battles that you need to fight and don't be comprehensive. So on that, I'm going to leave this point, Mr. Chairman.
And you can't leave that fast, because you will be introducing the next topic, and that is about international best practices, and you've already given us a hint of that. So may we request you...
Manish, weren't you going to take the lead on this one now?
Would you like to?
I can be very brief on this before handing over to Jackie and Bill. I think the third theme that we wanted to address was effectiveness of arbitration and efficiency of arbitration. And I just wanted to pick on two ideas regarding emergency arbitration and imposition of time limits on arbitrators, because I think these are areas where I think states in this part of the world, the practitioners and institutions have shown that they are not simply rule takers. They are pioneers in developing arbitration law and practice, and therefore you can't always assume that Western templates would be followed. And just to kind of give you a comparative perspective, let's take the topic of emergency arbitrations. We know now in India, after recent series of judgments, that emergency arbitrators' decisions in domestic arbitrations or even in foreign arbitrations enjoy much greater enforceability in jurisdictions such as India and Singapore as opposed to England. I don't need to tell you about the position in India. Of course, you're all well familiar with the recent rulings giving real teeth to the decisions of emergency arbitrators in the Indian context. But if you compare the position in England, and this comes as a surprise to many clients actually, albeit emergency arbitrators' decisions enjoy a high degree of voluntary compliance, but if there was a recalcitrant party, as things stand under English law, the position is wholly unclear as to whether you can enforce an emergency arbitrator's ruling, whether in a domestic arbitration seated in England or a foreign seated arbitration in the country. And in fact, this is a topic that is being discussed in the context of the ongoing reform of the English Arbitration Act. But as things stand, I think Singapore and India and some of the other jurisdictions are perhaps ahead of England in offering that clarity. The second point I wanted to raise again relates to the imposition of time limits on arbitrations. Again, all of you are well familiar with Section 29A and the time limits that are imposed in relation to purely domestic arbitrations seated in India. And again, we've heard conflicting views on that. I think there's a view that these time limits are an unnecessary intrusion into party autonomy. For example, why should the parties only be able to extend the time limits by only 6 months if the case is quite complex? But again, everybody we've spoken to and most of the people we've spoken to in the last few days have actually said that this was a solution that was absolutely critical in the Indian context. The time limits have worked really well. And indeed, they're not perfect. They may well be phased out over a period of time. But in order to effect that change in mindset, to change the practices, they were absolutely critical. And I think it may be that other states will look at India and its experiment with time limits and draw some lessons from that, because we know that this is something that the users of arbitration have asked for a very long time. And we know that albeit these limits have been provided in some other contexts, they have not always been observed. And I note, for example, in the most recent amendments to the LCI rules, and Jackie can speak further to that, your time limits have been inserted. And again, institutions are now playing a much bigger role, including the LCI, in policing those. But again, India's experiment with time limits in the legislation, as I said, may well become the model for other states to follow as well. Of course, with tweaks and as we, refine the law with experience.
Jackie.
From an institutional perspective, the role of an institution is effectively to provide a toolbox. So I started my initial comments by talking about the importance of national legislation, where you find many of the fundamental boundaries. But as an institution, you provide a toolbox, and not so much hard and fast rules. You provide options. So, for instance, the option of emergency arbitration, and that can be an effective tool if there is something genuinely urgent that needs to be addressed. But obviously, the mandate of an emergency arbitrator is more limited than of a tribunal that deals with the case on the merits. So it's a choice then for the parties whether they utilize these tools or not. And rather than going through the various options such as emergency arbitration, expedited formation, some institutions have fast-track provisions. I think what is essential when you review the toolbox is also to look at how the toolbox is deployed. And there you see different attitudes from different institutions. And that can be a matter really of experience. It's not necessarily something that shouts from the paper that the rules are written on, or shouts from the website where you find the institutional rules. It is the attitude. Is the institution available when you call them up? Is it something where you need to wait for a formal decision, or can you just get some nudging from the case secretariat? And I think at the LCA, you will see that there is less in terms of, there are no formal fast track or small claims provisions. But what we do see is that in practice, the smaller claims get conducted more quickly even than the average 18 months that we see. On average, they're done in 12 months. And I like to think that is a combination of providing explicit tools, but then having human beings implementing those provisions. And that's a segue to my neighbor on the right, because the institution facilitates and controls the arbitrators. But at the end of the day, it is the arbitrators who decide. So over to you, Bill.
Thank you. We're meant to have 15 minutes of questions, and we're not going to give you 15 minutes, but I'm going to say to 1 minute, and you'll have 10 minutes, I suspect. If I had one bit of advice in terms of how parties can ensure that their arbitration is managed efficiently, it is in the choice of your tribunal. I'm not in favor of domestic legislation telling you how to run your arbitration. Institutions are not going to put time limits on things that are binding. And so get a tribunal that is known how, has a reputation for doing a good job. And for that, you need an effective chairperson. And the most effective chairperson is one who is able and knowledgeable on how to manage processes, and most important, because the chair will have the pen in writing the first draft of the award, you want a chairperson who is known to get her or his awards out within 2 or 3 months of the final hearing. and there are lots who can do it, and I'm afraid there are a rather reasonable number who don't. So avoid them like the plague. And over to the chairman.
I'm not going to make any concluding remark right now because we are running short of time. So would any of you like to ask any questions to any of the panelists?
Do we have any questions from the audience? I did see some hands going up, though.
Well, before a hand goes up, may I just mention, Professor, that you mentioned about the importance of confidentiality. It is taken very seriously over here, and I think it is the Delhi High Court that has taken the lead on the question of confidentiality club, right? So a lot of people have followed it. Would it be advisable to have a minimum confidentiality requirement, minimum requirements, and anyone can add to it? Do you think that would be a good idea?
Do you mean as a statutory provision?
Yes.
Yeah, well, I think one of the issues, I was very brief in my comments, so one of the problems I think with confidentiality is that it is a complex terrain. So carving out certain areas of the law where confidentiality is not appropriate may be a reason to put nothing in the law, not even the minimum you're talking about. So for instance, investment arbitration is an area where people recognize that actually transparency is the driver rather than confidentiality. So how do you define investment arbitration? There could also be other areas of the law. The Law Commission came up with family law, and child protection provisions, which I didn't think was the most persuasive argument they could have found. But I do think that there is an issue about boundaries, what you do and don't include. Who are the players that are going to be captured by a provision? Is it the parties only? Is it the arbitrators? Is it the institution that is involved? So the moment you start drafting, it becomes difficult. And that is why there is no provision currently in the Arbitration Act, because it was deemed ultimately too complicated to do so. And that would be the case even with a fairly bare minimum provision.
Probably with the option to the party to opt out, maybe. Is there anybody else who has a question?
Just Vazifdar, could I just comment on that? And I'll actually be interested in our delegates' views on that, because my understanding is that under the Indian Arbitration Act now, there is a provision, Section 42A, maybe, right, which maybe...
That's a question. Yes, sir?
Yes, yeah, that is exactly my question. As per Section 42A, the parties have to maintain confidentiality unless they enforce the award. Whether that is a good thing or a bad thing. And secondly, in my limited experience, I have seen that there are instances where the parties to the arbitration has given false evidence under oath. Then how do we deal with vis-a-vis the provisions for the perjury?
I think false evidence would be a different thing altogether, but...
Maybe Manish wants to.
I think with Section 42A, the difficulty I have with that provision is a bit which says, notwithstanding anything contained in any other law for the time being in force, the arbitrator, the arbitral institution, and the parties to the arbitration agreement shall maintain confidentiality of all arbitral proceedings, except, as you said, when it comes to the enforcement of the award. But that is imposing confidentiality as a mandatory requirement, something from which I understand, based on the drafting of the law, you wouldn't be able to opt out either, even if the parties so desire. And
anybody else has any other questions? Yes.
There's a question there on the second row, please.
On Section 45 of the Indian Arbitration Act, which is equivalent to Article 2, Roman 2 of your convention. Whether the examination of the arbitration agreement under Section 45 is prima facie or it has to be final?
I am sorry, I probably have a view on that, but it's a question of law, which I told you. Unless one of the panelists have any idea, but may I refrain from participating in that discussion? Do you have anything?
There is another question there at the back. Sorry? Oh, I'm so sorry.
No, I think it may be that our colleague in the audience may well be able to address that as well.
My name is Nusrat Hassan. I'm the managing partner of Link Legal. My question, Professor, then do you mean to say that confidentiality is overrated? Secondly, we face an issue on confidentiality on a separate aspect. We had an arbitration in Singapore where the award went against our client. And there was on a similar issue, a parallel arbitration going on, a connected arbitration in India, where we took the plea that you could not use that award for the benefit of this tribunal in India because confidentiality had to be maintained. So there was a whole argument on that. But do you mean by that confidentiality or the confidentiality of the process of arbitration? Because I think by any application going to the court, the confidentiality really collapses. So I don't know, maybe I agree with you, Professor, if that's what you mean, that confidentiality probably is overrated.
I did not say, and certainly did not mean, that confidentiality is overrated, so I must have been very unclear. I described the difficulties of providing in a short provision, comprehensively and accurately, what confidentiality entails. And the second part of your question is a very good illustration of why this can be so tricky, because there will always have to be exceptions. For instance, if you're a publicly listed company, you may need to inform your shareholders about the outcome of a case. It may be that you have a legitimate interest in divulging the upshot of the arbitration award to other authorities. That may not mean necessarily sharing the pleadings exchanged in the arbitration, and it may not be something you can share with the entire world, but these are considerations that need to be taken into consideration. I would recommend the ILA's report on confidentiality and the very comprehensive draft provision you will find in that report as a good start. But more than anything, I would suggest you try to look at the institutional rules that have grappled with this issue, and the LCA rules are one of the very few rules that have an explicit provision in Article 30, which will give some guidance.
All right, we have couple of minutes. We have overshot the time limit, but a couple of minutes won't do anybody any harm. Any other question? Yes?
Yes, I think there's a question.
I am Jaya Goel. I am Jaya Goel from IMAS. So I have a question, or just a thought, sir, from the chair, that don't you feel that gender diversity we are lacking in arbitration? We hardly have many women arbitrators in India or women lawyers. So shouldn't we concentrate on that also? Gender diversity.
I think the Chief Justice of India made it very clear yesterday.
Yes,
in more ways than one, and I don't think there's any difficulty. There's a young lady over here who was really the captain of the team before me in a big arbitration.
Yes.
Yeah. So
yes.
I don't think we've ever had a problem. At least I, fortunately, have never had any problem so far.
Yes. Thank you,
and
sir.
I'm sure I won't have any.
Sir, there was a complete session on this issue.
Yeah, I know. That's why. Yes. Anybody else? Well.
Can we have some concluding remarks from Justice Vazifdar?
Yes.
If I may request, please.
Quickly. Oh, I'll make it short. Thank you very much to my panelists. As it was, there's only one thought that crossed my mind. There was a very major emphasis on the seat. Absolutely correct. There was a major emphasis on emergency arbitrators. Absolutely correct. So would I be that wrong in saying that we must have some certainty about both these issues? Because when you have a seat properly constituted, you also need to see whether that seat, the orders and judgments from the seat are or not to be binding on others. As I say, certainty is necessary. I don't think there's a problem on the law, and the law can always be changed. We are pretty robust over here. Yes, I don't think there's denying the fact that we have some difficulty about arrears in courts, but some of the major international arbitration matters go essentially to the, mainly to the commercial courts in Delhi, Madras, Calcutta, Bombay. And I think that there is definitely a pro-award attitude. You don't just set aside awards easily. But as the Chief Justice of India said yesterday, that residual power must be there. And I think I totally support that. It must be there. It's there all over the world. As far as the best practices is concerned, I think it's a topic for an entirely one session in itself. I think one danger is some people seem to think that one size fits all applies to arbitration rules. There is a fundamental difference in the culture. Now, when I say culture, I mean the manner in which the record is maintained from country to country. Simple example, and I said there are matters ongoing, so I don't want to tread into something what's happened just now, but 35 years ago, for instance, one of the biggest problems was that certain types of corporations do not maintain a proper record. Now, when I say maintain, I'm not talking about storing it, but actually recording what has happened. There are even 35 years ago, there were certain corporations who could foresee an arbitration and actually had 2 or 3 officers see that their correspondence was perfect. Now, in such cases, to have rules like failure to cross-examine will not be held against you doesn't apply. So you really, I think we have to stop saying that, oh wow, this is an international commercial arbitration and therefore this rule, these rules should be applied. No. I think lawyers have to first, and in fact, Abhinav Bhushan told me that it's called the midnight clause, because it's done at the end, so you just copy-paste an arbitration clause somewhere. I think it should be called the winding up clause, because when you're winding up your agreement, you have a copy-paste job of an arbitration agreement. It does not help. I'm sorry, but through personal experience, even at the time of the preliminary meeting, sometimes we say, okay, LCIA rules apply, MCIA rules apply, IMC rules apply, without actually knowing the record. My suggestion there is, please know the record, know the exact nature of the reference, and then agree to the arbitration rules.
Thank you so much.
That's it. I think we'll wind up here. Thank you very much, especially to the DIC once again for a wonderful.
As we close this day 1 with this session, I'm grateful to Justice Vazifdar and this panel of distinguished guests for leaving us with a number of thoughts to ponder on. This is what happens at the end of the day.
That was a Freudian slip. They almost extinguished me anyway. So.
Before we reconvene for tomorrow, Rudyard Kipling may think the East never meets the West, but I think our panel of experts has clearly shown us otherwise.
Yep.
I thank all of you again for being here today, and I also thank our audience for making day 1 extremely successful. We are very happy with the turnout that we've had today, and we look forward to seeing you all tomorrow. Thank you so much, and I'm very happy to also announce that we are open for evening tea, which is on the 7th floor in the coffee lounge. So see you there.